So what you just put up on the screen and what you argued, and I said, hey, pull that up for me. Not in your opposition, is that fair?
That is fair, Your Honor, yes.
So tell me why I should consider it then if it's not in your brief. So next up, I think I have, but feel free to correct me if I'm wrong. Real Water's motion for summary judgment regarding claims made by the carrier plaintiffs and Rudy Morales.
Rudy Morales, we've stipulated to dismiss that each side bears on fees and costs. So Rudy Morales isn't part of this.
Okay. Anybody disagree with that?
No, Real Water agrees that Mr. Morales is no longer a part of this action.
Okay. So then we're just talking about the carrier plaintiffs?
That is correct. That is correct, Your Honor.
Okay, so I'll tell you what I'm inclined to do, although I certainly welcome arguments, you know, inclined to grant carrier plaintiff's argument, you know, rightfully concedes that they don't have any experts, but argues, well, they don't need ones in this particular instance. I think it is significant as compared to some of the cases relied upon by the carrier plaintiffs, that here defendant, you know, do have experts who've offered opinions that this is not caused by, or the issues caused by, you know, Real Water's product, there are no plaintiff expert opinions, but welcome arguments begin with whomever is arguing on behalf of Real Water.
Thank you, Your Honor. Matthew Kaufmann on behalf of Real Water. Can you hear me all right?
Yeah.
Okay. Given what you stated in your inclination and the fact that you basically just read the main points of my reply back to me, I think I'm just going to stand on your inclination and reserve some time for reply.
Okay. Anything in opposition?
Yes. And then, sorry, Your Honor, this is Ariana with the carrier plaintiffs.
And you can come up to the podium maybe so I can hear you better.
The Milwaukee parties also filed a motion for summary judgment against carriers' claims raising the same arguments, and so I just wanted to confirm with you that in opposition I addressed both of their motions.
Okay.
All right, Your Honor, so I'll just get started. So the issue here is whether or not we were required to have expert testimony as to causation of our clients' illnesses. But the biggest thing here that it's well accepted that there is no expert testimony required to establish causation when the injury and the cause of the injury are either readily apparent to the jury or it is within the jury's comprehension. And in our brief, we cited multiple cases where there were circumstances that did not require expert testimony, and I kind of want to get into some of those here, but I do want to start off by saying, just kind of really going through the evidence that we do have in this case and the evidence that's been produced. And whenever the Nevada Supreme Court or other jurisdictions are determining whether or not expert testimony is required, they're not just looking at, you know, have they produced an expert? They're looking at what is all of the other evidence in the case. Like, what is the other expert testimony establishing? What are the facts? They're looking at everything from sort of a totality of circumstances situation. And here we have a situation where there's no dispute, or at least it's not disputed, that hydrazine is toxic, that hydrazine is a proponent in rocket fuel, that there is expert testimony in this case on the defendant's side and plaintiff's side acknowledging that hydrazine is toxic. Here, we went through a list of evidence in our motion, and we have Dr. Kosnet for the plaintiffs who opines on, general hydrazine exposure. And in his report, he mentioned, and he cites a study where a man there was exposed to occupational hydrazine, and he had upset stomach, he had vomiting, nausea, or vomiting, it was issues of coma. And so here, when we look at all of the symptoms that, I'm so sorry, Ariana, let me actually just take this back, because I think that was a little bit out of order there. But I think the biggest point here is there is a ton of evidence in this case, a lot of evidence in this case, where the jury can make a very logical, strong inference between the evidence that we have and the consumption of real water and our clients' illnesses. To be clear here, Ryan, Erica, and Finn, they all suffered vomiting. Erica didn't suffer vomiting, she suffered headaches and stomach aches. But Finn and Ryan suffered nausea, vomiting. They even suffered nausea and vomiting on within 24 hours of the time that Hera was sick and hospitalized. And that's one thing that the defendants do note in their opposition, or in their motion, in their reply of, well, these symptoms weren't temporal, they didn't occur within the same time period, but that's actually entirely belied by the record. Here we have a circumstance where Hera Carrier was hospitalized November 2022. Hera is not a subject of any of their motions, and the very illnesses and the very symptoms that Hera suffered overlap with the very illnesses that her father and her dad suffered. Headache, vomiting, not feeling well, things like that. We need to be mindful of the fact that Real Water here has conceded that there was hydrazine in the water, that hydrazine caused Hera Carrier's illnesses, not just her acute liver failure, but everything attendant that went along with that. And in that same stipulation, they make reference to other plaintiffs, the Williams twins, the Wren family, Seven Morales, where they also concede liability and causation in those cases, and those same plaintiffs also suffered the same exact symptoms or similar symptoms to the ones that Finn and Ryan suffered. And the defendants make an argument that, when you are trying to prove causation on complex internal injuries, expert opinion is required. These are not complex internal injuries. These are headaches, stomach aches, vomiting, and there is no law, and defendants have at least not cited any law, stating that as a matter of law, these subset of symptoms require expert testimony. All of it is going to be case specific. All of it's going to depend on the evidence and the other testimony in the case. And just going through one case that I found that is actually very applicable here is defendants referenced Leighton v. Yankee, and in that case, it was a Ninth Circuit case. There, a bunch of homeowners had brought a lawsuit against a power plant because that power plant was emitting what they alleged were fumes that were causing illnesses such as headaches, nausea, vomiting. In that particular case, the court said that there was no evidence other than the plaintiff's own testimony that established a link between their injuries and the particular chemical in that case, which was hydrogen sulfide. And this is not that same situation. We don't have a situation where the only thing that would connect our client's symptoms with the consumption of real water, that it's just their testimony. There's ample evidence in the case establishing the kinds of impact that hydrazine can have on the human body. There is expert testimony that links the causation of Hera's injuries with the consumption of real water. This is the same family that they live under. Yeah.
So let me add, not everyone who drank real water had symptoms. And so how do you link, hey, these what are fairly vague, generalized types of symptoms like vomiting, headache, nausea that can be caused by all sorts of different things. I mean, how do you present that to the jury and say, hey, we don't need expert testimony to go into causation when you have those two pretty key, like, you know, not everyone who drank well water got sick. And, you know, these symptoms, I mean, I think all of us could probably say, hey, I vomited before, I never drink weir water, I get headaches, I don't drink. How do you skip over the general rule of you do need an expert to talk about medical causation?
Absolutely, Your Honor. And symptoms, let's just for the purpose of this argument, let's just say headache or vomiting. Let's just go with those two symptoms for right now. Those are absolutely general, non-specific symptoms in a standard circumstance without any other information. But in a case like this, where you have all of this evidence in the case, where you have expert testimony, you have medical, scientific, and general evidence in this case that is specifically linking these symptoms to the consumption of real water, here, that's what makes that different. This isn't just us saying, you know, our client suffered these symptoms, it must be related to real water, and there's nothing else for the jury to go off of here. Here we have a CDC report where when they performed a case study to create a case definition, they specifically linked these common symptoms with the consumption of real water: fatigue, vomiting, dizziness. There's peer-reviewed literature from the CDC that links hydrazine with upset stomach, vomiting, and other symptoms. And here in this particular situation, we have expert testimony establishing the link between real water consumption, Harris illnesses. Hare, Ryan, and Erica and Finn, they all lived in the same household. The jury can make a very logical, quick inference there that, well, if this young child had this illness, it was caused by real water. The defendants real water is admitting it. There's expert testimony establishing that. There's no dispute. They're not disputing that Ryan, Erica, or Finn suffered any headaches or any vomiting or any dizziness. That's not a dispute here. With all of this combined, the jury can make a very logical, quick leap there, and therefore that's what renders this within the jury's common knowledge. And that's something here that we really wanted to drive home, because in defendant's reply, they ignore all of the evidence, all of the cases that we cite. And these cases are very, very clear that if there is general causation evidence, which we have here, general causation meaning, can hydrazine cause these symptoms? Yes, we have that. And then we have specific evidence in terms of, we have other evidence that also drives that link a lot closer. So we will say this, defendants didn't cite one case that involved a circumstance where there were multiple plaintiffs. All of these plaintiffs suffered the same illnesses. And, you know, despite expert testimony in that case, there being medical and scientific evidence linking that particular toxin with the illnesses that were alleged, that expert evidence was still required. Like, they didn't cite any cases like that, and we cited numerous cases. And Your Honor, if you're just indulgent for just two more quick cases that they do highlight, is aside from the Leighton case where there was absolutely no evidence in that case establishing that hydrazine sulfide caused those injuries. Here we have that. They also mentioned, or we also cited, the Amos v. Coca-Cola bottling, and in that case, that was a matter where the plaintiff had drank a Diet Coca-Cola and had 2 batteries in it. And there, the jury found that it was unfit for human consumption. But based on that alone, the fact that the jury, and the evidence allowed the jury to find that it was unfit for consumption, the jury was able to confer based on the temporal proximity of that plaintiff's injuries, where they had just drinking the Coke, they had those symptoms. Here with us, very same thing. Hare is drinking this water, and around the same time Hare gets sick and she has to get rushed to the hospital is the same exact time that Ryan and Finn are experiencing the exact same symptoms. It's noted in Hare's medical records. The plaintiffs discussed it in their testimony. So there's a lot of things here. It's not just a situation where you're just saying, hey jury, just make this leap that hydrazine could have caused these issues. This here creates a genuine issue of fact as to causation given all the other evidence in the case. And we can't ignore that. And Your Honor, and there was one last case that defendants do try to distinguish, and I do want to make this clear here, is this was Guidry v. Dow Chemical Company, and that was, the issue there was whether or not the release of an ethyl acrylate was causing specific symptoms in that plaintiff: headaches, dizziness, trouble breathing. that was another example where the court said expert testimony is required to prove this because there's no other evidence at all in this case establishing the link between this ethyl acetate and the symptoms that you're experiencing. And again, that was one plaintiff, not multiple plaintiffs experienced the same thing. We did cite another case out of, I believe it was Texas, and in that case, it was a family. A family had been exposed to an oil spill, and the entire family suffered those symptoms. And there, the court found that expert testimony was not needed because the jury could reasonably infer that given they were all exposed to it, they all got sick within the same time frame, that was in and of itself sufficient. And so we will just rest with just resting on the fact that there are genuine issues of fact here. We've established that by pointing to the testimony, the other evidence in the case, and the jury here is not going, at least in our view, would have no issue making that connection.
Hopefully a quick question. Are your clients claiming that the symptoms are still ongoing?
No, Your Honor.
No. Okay. Thank you.
Thank you.
Okay, any rebuttal?
Just very quickly, Your Honor, I'm just going to hit a couple of high points. One, plaintiffs said we failed to rebut any of the cases that they cited to, but if you take a look at our reply, we actually went through and addressed I believe we addressed every single case they cited and distinguished them from the cases here. Also, at times, plaintiffs' opposition kind of confused me because they seem to keep stating that the court said you needed to have an expert to tie this together. And what they don't have here is an expert to tie this together. Dr. Kosnet has no specific opinions. He testified to that in his recent deposition. He specifically said, I have no plaintiff-specific opinions in this case. They're all general causation. And as to the commonality, I think they are actually requesting that the jury make an assumption as to causation here. I don't believe that there is that they've established a temporal causation, and I don't believe that that the jury can make that inference. I believe that the Nevada law is very clear that you need an expert opinion to diagnose internal injuries. I would also note that plaintiff's own expert, Dr. Hudson, has basically testified that the symptoms discussed here about nausea, headache, this kind of vomiting, they are general symptoms. And the way to determine if they're a liver issue is by objective testing. And there's no expert here. And at the end of the day, and I believe your initial inclination is proper, and our motion should be granted, Your Honor. Thank you.
Thank you.
Your Honor, John Davis, just for Milwaukee, we filed substantially the same motion. I will just echo what Real Water just argued and reiterate that Nevada law is very clear that if an injury cause is not apparent, you've got to have an expert to give testimony on it. And again, we just don't have it. We don't even have a treatment provider who can shed any light on that. So we'd agree with your initial inclination as well.
Thank you very much. So I'm going to stick with my initial inclination, grant the motion, and I can't remember if it's a separate motion or a joinder, but there are no genuine issues of material fact. We do not have, plaintiffs do not have, rather, an expert to link specific causation to these three particular carrier plaintiffs. The injuries and the causation are not the types that would be readily apparent to jurors. I think Nevada law is pretty clear on that it would be required in this type of case. It's not, you know, I got hit by a car and my arm broke. That's not this type of case. The symptoms are generalized, fairly vague, etc. Temporal connection is also not immediate, as some of the cases relied on plaintiffs are. And therefore, court grants the motion, joinder. You'll need made findings of fact, conclusions of law, make them detailed. I'm not reading through the briefs, but you'll incorporate those and submit them to opposing counsel for review and approval.
Sounds good. Thank you, Your Honor.
Thank you. Next up, I think we have Real Water's motion for summary judgment regarding independent claims of parent/guardian ad litem plaintiffs. Anybody disagree that we can do that one?
We agree.
Okay. So I'll tell you what I'm inclined to do is deny it. Because genuine issues of material fact exist and notice was provided in discovery. Pretty simple kind of reasons there, but welcome arguments.
Thank you, Your Honor. Joel Odou on behalf of the Real Water defendants. Be fairly brief here. There were two grounds that we brought the motion. The motion is very specific and very targeted. This isn't a motion for summary judgment as to any independent claims that were verified in discovery. This is just the bystander claims, if you will. And really, our argument is twofold. One is a violation of 16.1, which I didn't hear in the court's tentative or inclination, and I think that's really where the rubber meets the road, so to speak.
I would say, I mean, I was kind of vague in general, but I think notice was provided in discovery. I think it's kind of what I said. Let's see. Sorry. Yeah. Okay, sorry.
No worries, Your Honor. If I could have Mr. Zamora have access, he could put up Exhibit F for us. F, the 16.1 disclosure dated March 7, 2024. There we go. So what I put before the court is, first off, this is a plaintiff's 16.1 disclosure, the 34th supplement. If you could scroll up, you can see the date at the top. Thank you. And then if we go right to page 100 of that, or page 98 first, what we'll see is after expert disclosure, in this case, Your Honor, Dr. Sands is attempting to offer opinions about emotional distress claims of the bystander plaintiffs, if you will. And the problem with that is twofold. One, as we'll see, those disclosures are in bold because that's the first time they're being disclosed in the case, and that is clearly too late. In addition to the problem of notice, Nevada's a notice pleading state. Certainly we can talk about the notice pleadings being lacking, but adding a claim of $103,200 per plaintiff at that late stage is improper. It's a 16.1 violation. So it's not, and Your Honor, the point of this motion was not whether or not the plaintiffs could bring a claim. The point of the motion was, did they bring a claim, and did they do it properly?
What was the date of that again?
It's March 7, 2024, and then Mr. Zamora, if you could go to a different page. It's page 368 of the PDF. It's the carrier disclosure dated April 1, 2024, and that's Exhibit H. You can scroll to the top of that document.
368?
Yeah, it's on, it's page 368 of the PDF. And, okay, so they're on page 19 of the, this is the April 1st disclosure, Your Honor, for the carrier plaintiffs. And what we have here, if we scroll down, we'll see future psychological and psychiatric evaluations, individual psychotherapy sessions recommended by Dr. Stephen A. Sands in the amount of $103,200. That is a carbon copy, if you will, for each of the bystander plaintiffs, whether they're the Wren plaintiffs, the Santee Williams plaintiff, or the carrier plaintiff. And the problem with those $100,000, 103 charges is that they were untimely, and that was another basis for a motion for summary judgment. And so we understand what the court is saying is that the plaintiffs have the capacity to make an individual claim, but the problem here is that they didn't do it timely. And for that reason, if the court is inclined to deny the motion, we would request it be granted in part, although there is a motion coming later, I believe, by one of the co-defendants to strike it. So one way or another, we think that particular claim is improper. And so we think the motion should be granted in part because those charges, if you will, were untimely, not properly disclosed. And we could, I know that we've got very, very limited time, and I want to be conscious of that. We could look at the individual complaints. If we look at the Cavey complaint as an example, we'll see that Santee Williams is only listed as bringing a claim on behalf of her children. She's the guardian ad litem, and that's true of some of the other some of the other Cavey plaintiffs who are no longer part of this case. But as to Santee Williams, who is still part of this case, she's listed only as a claimant as a guardian ad litem, not personally or individually, whereas the carrier plaintiffs were properly listed, but they never properly disclosed their damages. Thank you, Your Honor.
Thank you. Who's up? Oh.
Thank you, Your Honor. So to start off, they say that the charges were untimely or improperly disclosed, but that doesn't make sense here given the fact that in Dr. Sands' expert report, which was filed on the day of the day it was due, it actually sets forth the computation of how he reached that. So for their argument to say that these charges were untimely, that fails in that regard. And it's also not a 16.1 violation because, well, number one, calculations were provided in Dr. Sands' report. All of the supplemental disclosures involving these damages were served prior to the close of the discovery deadline, and defendants sat on this entire argument. When they first got Dr. Sands' report on February 5th, they could have disputed his opinions in there regarding future treatment for the parents, and they didn't. And so,
can you turn me just so I can double check? Turn me to his report where he says that.
absolutely. Apologies, Your Honor, we're pulling this one.
Okay. Between how many are there?
And Your Honor, apologies for the delay. The Sands report was not a exhibit in our opposition, but we will pull that up. It has been done in the case. And Your Honor, we actually just pulled that page of Dr. Sands' report. It's in Sands 36, where, and these are in his opinions, where he mentions.
So let me pause you because I want to make sure.
Of course.
There have been accusations on both sides about arguments, etc., that aren't in people's briefs, accusations flying back and forth. So I think I understand what you're saying, but I want to make sure because, So what you just put up on the screen and what you argued, and I said, hey, pull that up for me. Not in your opposition, is that fair?
That is fair, Your Honor, yes.
So tell me why I should consider it then if it's not in your brief.
Because we do, so in our brief, we do highlight that there is no dispute that his report was timely produced, or there's no dispute that his report was produced on February 5th, 2024.
So where am I looking in your brief?
And in the brief, oh.
Yeah, yeah. I mean, it,
So in the brief, on page. You're on the brief on page 5 on the opposition.
say that again, page 5, what?
Yes, page 5, I'm so sorry, page 6 on the opposition.
Okay.
And on page 6 on the opposition, this is where we discuss the, or sorry, wow, okay, so page 5 through page 6. So we have our future medical treatment on page 5, that is continued on page 6, and here, our argument is we make this argument in this brief, but our argument here is that any damages that Dr. Sands rendered, those damages were disclosed in his report, which was produced on February 5th, and they were also provided in the supplemental disclosures of the plaintiffs, and those were all provided during the discovery period.
Okay. Anything further?
And Your Honor, at this time, there is nothing. Your Honor, at this time, there is nothing further. We would just ask that the court consider that that report was timely produced, and there isn't any dispute that Dr. Sands' report wasn't timely produced on February 5th.
Thank you.
And that these damages were all disclosed in the supplemental disclosures.
Thank you.
Thank you.
Any rebuttal?
Well, Your Honor, if I could just be heard on a couple quick points on behalf of my clients in this.
Sure. Was like a joint opposition? No?
Well, Your Honor,
I
they
thought
seek summary judgment on all the parent claims. Ms. Carrier, or Ms. Reed represents the carrier plaintiffs. I represent the other children's parents.
Right, so, but you both, I mean, I'm looking at the opposition. It's, at least the title page has her and you guys on it.
Yes, it's a joint opposition.
Okay.
Okay, and I'll be brief. Just a couple points to add. Number one, you know, what you heard from Mr. Odou was they don't challenge our ability to bring these claims.
Mm-hmm.
They just challenge whether we did. On that point, I would note that these complaints are pled in the exact same way that they were pled in the Gallagher case, which also involved an infant who was injured and his two parents. And his two parents, as referenced in the real water motion, they were on the verdict form. They were awarded general pain and suffering damages related to the incident involving their child, and they were on notice that we were seeking the exact same thing here. The other point I want to raise is that in terms of the damages disclosures that they're complaining about, the disclosures are limited to, or the computation disclosures are limited to special damages. And so there's no requirement to disclose pain and suffering. And so just like in Gallagher, there was no disclosure there. That case didn't involve the parents needing.
Yeah, so I don't disagree with you on that, but part of his argument at least is more nuanced or more particular, however you want to put it, in terms of, you know, this 103,000 or so amount, you know, being too late, untimely. Your colleague's opposition was, well, we did disclose that on February 5th in Dr. Sand's report. That's where I said, well, show me, because I'd like to see that.
Yes, Your Honor, and I agree with that position. My only addition to that is it's not a summary judgment on these claims based on the timing of the disclosure of the special damages portion of these claims. That's a discovery issue that they didn't brief. They're just seeking summary judgment on the assertion that they weren't timely disclosed. But as Ms. Reed capably argued and showed, we disclosed those damages as soon as we knew that they existed. We retained an expert. He evaluated it. In his opinion, he recommended these future psychological evaluations and counseling sessions. We disclosed that, including the amounts in his report. We supplemented our computation of damages based on that soon after. Real Water retained its own expert after that fact on these issues. So really that discovery violation is kind of a red herring here, and it's not a basis for summary judgment in the first place. So we would ask that you deny this motion for summary judgment, because there's really no basis to say, as a matter of law, these claims are improper, which I believe was your inclination at the outset, Your Honor.
Thank you very much. Any rebuttal?
Yes, Your Honor, very briefly. I'm going to ask Mr. Zamora to pull up Exhibit B of our motion, the Cavay complaint, and in particular, the court will notice in the caption, we have the Cavays, obviously, whoops, we lost it. And then we have the Williams children by and through their natural mother, Santee Williams, and then it goes on to Severin Morales by or through his natural father, George Morales. Then it says Joseph Tagano individually. So somebody won $300. You still win it? The price
Too
is
bad
right.
the jury's not here, right?
So, Your Honor, this is our point. Right from the start, Nevada's a notice pleading state. In the other complaints, it says individually when plaintiffs are bringing their claim. This does not for Santee Williams. It does not for George Morales. So right from the get-go, we have a problem with the complaint. We understood the complaint was on behalf of the children. It's being brought by their parents pursuant to the statute, and that's what I meant when I said, did these plaintiffs have the ability to bring a claim? Sure. If they put individually after their name, we would have been on notice that they were individually bringing a claim, and that exists for some of the plaintiffs, but it doesn't exist for these two plaintiffs. The other point I would make is Mr. Pepperman is wrong on two accounts. Mr. Pepperman cites the Gallagher verdict. Well, Real Water settled with the Gallagher family before trial, so the Gallagher verdict was of no concern to us as far as Orion and Camille and Brian Gallagher go. I think it's Brian Gallagher. And so that's a non-issue. The other issue I would point out is in the opposition, the plaintiffs had the opportunity to attach Dr. Sand's report and to point out in Dr. Sand's report where he says that he is articulating injuries on behalf of the parents. He does not do that in his report. Plaintiff just argued about psychological counseling for Layla Cavay. We were aware of that. But Dr. Sands didn't timely put in there that he wanted psychological counseling for Jill Raw or Karush Cavay or Brian Wren or Emily Wren or any of the parents. That's where it's untimely, and it absolutely is a motion for summary judgment because there has to be competent admissible evidence to resist the motion for summary judgment. So the motion is proper. It's not just a discovery motion. We're going to see this again with a motion to strike Dr. Sands, but for those reasons, we think the motion should at least be granted in part.
Thank you very much.
Your Honor, Dawn Davis for Milwaukee, we joined this motion. I'm not going to rehash anything else. I just want to, as Mr. Odou said correctly, we do have a motion to strike Dr. Sands for some of the reasons that have been outlined here today, among many others. But as part of this streamlined discovery process, we have been asked to rely on plaintiff fact sheets that are filled out under, I believe, penalty of perjury. And I'll tell you that each one of these plaintiffs filled out the question with regard to psychological injury as none being sought. So it's just another point here in support of our joinder to Waters motion.
Your Honor, we had also filed a joinder as to the Cave parents. I don't know.
So let me pause, everybody. I mean, we were doing so well this morning in terms of, you know, move-in / opposition / reply, and the joining party's supposed to be, you know, concurrent with, or, you know, to the whichever you're filing a joinder to, and now we're having plaintiffs argue about something that they, for whatever reason, failed to, neglected to, omitted to put in front of me, and they were previously accusing defendants of doing that similar type of thing, and now we have arguments that I thought were complete after rebuttal, and now we're saying, hey, we joined, so we're going to go ad nauseum, I guess. So go ahead, whoever's up.
I didn't have anything substantive to add. I just wanted to.
Your Honor, this is Sam Mirkovich. I just, the hearing on the motion related to Dr. Sands is set for tomorrow, or maybe it's the day after. I think what Ms. Davis is getting into borders, it encroaches into arguing that motion. And I want to point that out. We can have that argument out tomorrow or the next day.
So what I need, you have a bunch of attorneys, so here's what I'm going to require you all to do. I heard talk about Dr. Sands included $103,000 for each particular plaintiff, I guess, although it's hard for me to know because I don't have that in front of me. I'm hearing argument on the defense side of, hey, fact sheets don't have any of this in it, we therefore don't have notice. So Dr. Sands, make a note of this, we're gonna, I don't know if that's set for tomorrow or Thursday, but it's gonna be Thursday. And you all need to file something before midnight tonight, both sides. I mean, you don't have to, but if I were you, I would. You know, plaintiff wants me to rely on something that's not in front of me, defendant wants me to rely on something that doesn't sound like it's in front of me, so file your supplemental briefs before midnight tonight, and we'll take this motion back up again on Thursday. And Dr.
And Your Honor, just for the record, I will not be here Thursday, but Mr. Kaufmann can argue after the law.
Okay, thank you. Are we done with this one? Okay. Yeah. Hannah's out, right? So
Yes,
no Hannah motion for summary judgment, correct?
Was moved by Milwaukee.
Oh, okay, so Hannah, this is defendant Hannah Instruments motion for summary judgment filed on April 5th at 5:28 p.m.
Is it motion for summary judgment number 1?
If it had a number on it, I would read it from the title, but, yes. Yes, according, so, yes.
Oh, I'm sorry, Your Honor, before you get started, I think this is practically the same motion you've already decided. Unless there's something new, I believe we did a joint opposition to this one and the one we argued earlier. I don't know if it's being repackaged, but I don't see what this is.
Part of it was, and I'm not going to talk about this.
19th affirmative.
Yeah, so there's 3 arguments: causation, lack of breach of warranty, which I will not discuss because that's already been ruled on, because it was the same horizontal privity kind of thing, and then the superseding cause. Those were the 3 arguments in the motion.
But how does that not, and Your Honor, I'm directing you.
So here's what I'm going to do. I'm going to tell you what I'm inclined to do, and
Sounds
instead of the back and forth, you'll argue to me, because otherwise we might be here a while. Inclined to deny because at the very least there are several issues of genuine material fact. And actually, and this probably goes to what Mr. Parker's trying to say, my note also, actually there are really no genuine issues of material fact in favor of the plaintiff. So I'm inclined to deny it, probably like I already did another one, but if there's a point you're like, I think what you're saying, Mr. Fears, there's something that we haven't already talked about, which is totally fine.
Well, I just wanted to, I want to lay out the record.
Yeah.
And then I'll be brief.
Sure.
I know some people may think we're plowing the same ground, but we want to talk about the causation. I will not address essentially was a Me Too on the standing on breach of applied. I'm not going to argue that. Let's say that. But our principal argument is that the lack of causation, and there's 4 areas where we think that there is a lack of proof on that. The first one is going to be, would the warning have made any change? That we have from the testimony of the employees, no. They never read the manual. They never read the things that would have prompted them to do something different to the extent it should have been different. We had that from Mr. Aiken. He did not read the manual. He was taught by his, I think one of the Jones individuals, I think Blaine, could be Brent. It's just escaping the top of my mind.
Sure.
You have other witnesses who were involved in this process that did not read the manual, and thus any change in the warning would have done nothing. The second point where there's a break in the causation change is foreseeability. Mr. Kemp did talk about this, about these emails, and I'm not going to dispute that there are emails talking about negativity and reading that. What we don't have is this, at least I have not been able to find it, whoever's going to argue in opposition, maybe it's Mr. Kemp can show those to me, is this, for lack of a better word, this knowledge that real water are really just alchemists. This idea that they just kind of make up this formula that we find out in depositions from Mr. Marlowe. I got to a point where I ceased to be sick. So you almost can envision him kind of, in those, Franciscan robes, some chains, can I turn lead into gold? I'm going to just kind of do this. Yeah, there's a foreseeability. There is no foreseeability on this, adding this poison, as Mr. Kemp will talk about, this rocket fuel into it. Was it marketed to test negativity on Kangen water? Yes, that is done by electrolysis. There's no added material. I haven't been able to find emails saying there's these chemicals we're adding and that's the reason. Are there emails about, hey, we're having some issues about reading negative numbers? Yes, I'm not going to say there's not. But the issue on the foreseeability is this kind of this alchemy. There is some company out there buying my product that are a bunch of alchemists just kind of mixing stuff until they get something. They didn't even know. In their depositions, they didn't know they were creating hydrazine. So to say that is foreseeable to the Milwaukee and the meter defendants in Milwaukee in particular, that's a break in the causation chain. The third one is there is no evidence that the meter took an inaccurate reading. There are no logs. There are testimony, at least from Mr. Aiken, and that goes back to the issue we have is this wasn't one batch of real water that was created that lasted years and years and years. Each one has batch. Best practices are you log the batches you make of the water and you bottle. I have been unable to find those. I have asked co-defendants, are there any of these batch numbers? They at least tell me they couldn't find it. Now maybe we just can't read numbers well, but we can't find these batches that would link it. And that is, and then we also, whether there's an accurate reading. The one, let's say a batch, which Mr. Kemp effectively, he affectionately calls the super bad batch, okay, is Casey Aikens. He will testify, I never had a problem with the meter. We have no evidence that when he took a measurement that the water he measured, now he does not stick the probe into the 100 vat, lack of a better term, cistern that has all the thing. He takes a sample out and tests that. There's no evidence that that the meter read that sample wrong. And we have testimony from our experts that there was issues with the mixing. We'll be talking about that later in motions in limine. But there are these issues that there is no evidence that it actually read incorrectly. And that was the whole point of our spoliation motion. Don't want to retread that. But this idea of we don't have the evidence that this meter tested poorly or inaccurately, especially with the super bad batch, which according to plaintiffs is really at issue with a lot of the plaintiffs in this case for the time period. We don't know if these people got that batch of water because we don't have the records. So that's the third issue with the causation chain. The fourth is medical causation. And Mr. Kemp will come up here and he'll talk about the phantom virus and all this kind of stuff. That's fine. But as you know, Your Honor, you've done pharmaceutical cases and I'm just taking cancer. You can't rule out every possible mechanism that could cause a person's cancer cell. You can't, and in this case, there are several of the plaintiffs. Some of them had extensive workup of the viral workup of, are there certain kind of typical, you have the typical, the Hep A through E. Okay, people usually get that. There's a different one, adenovirus, other these things. Some of these people did not have that workup. So there's an issue with causation, at least with our expert. He did consider, the hydrazine, and then said these are more likely causes. So those are the four areas where there's a break in the causal chain. And if I go back to the third one, that goes to my last argument of the superseding cause, is we don't have that foreseeability of these alchemists running around making this water and then doing what they did. We have no evidence that the meter was inaccurate. There is no. You can say, well, people got sick. Okay, that's circumstantial, but we're talking about you have to link these batches. And we don't have that, and neither does plaintiff. And so for those reasons, we would ask you to grant the motion based on lack of causation.
Thank you very much.
Your Honor, I don't see how this motion is completely moot. The court has already made a determination based on issue preclusion, finding liability against Milwaukee. And I've just heard Mr. Fears argue what we've argued earlier today. He's touched upon arguments made in terms of foreseeability, which we've already discussed. He's touched upon causation, which we've already discussed. He's gotten into what I would consider to be the jury's decision in the Gallagher case. He's just rehashed everything we've heard in an attempt to circumvent the ruling that was given this morning. Your Honor, I would love to address the factual issues he's brought forward. In fact, I will say, giving credit where it's due, I thought the picture he was creating of someone in the dungeon with a cauldron making something, I thought that was pretty good.
That's probably fairly accurate, sounds like.
Yeah, that's what I thought myself. Now, does it have anything to do with this case? Probably not, but it still painted a pretty interesting picture at roughly 2:46 in the afternoon.
I mean, I could see that in closing argument.
Me too. I could too, Your Honor. I was thinking to myself, man, if he just had not lost the motion this morning, that would be a great one to put out there. But, Your Honor, that's not what happened here. And just like the deference I gave Mr. Kilroy, I'll give it to Mr. Fears as well. He wasn't in the first trial. They resolved or settled the second trial. So I will say this, Your Honor. What we do have here, and what we do know about this, is Mr. Casey Aiken, who Mr. Fears referred to 2 or 3 times now. Mr. Casey Aiken said that the determining factor what led him to add more or less C2 concentrate was the meter. The emails that he's speaking of, I had the pleasure of putting them now in front of a jury and looking at them over and over again. Those are emails between Milwaukee's general manager of operations, Mr. Jason Brown, who indicated that he'd sent responses back to other purchasers, including Real Water, about how to use it and how much time it took to condition the probes. And he knew that they were using it for alkaline water as well as Kangen water, trying to achieve a certain level of alkalinity. Your Honor, I for the life of me, I enjoyed the references and the picture that was being painted, but that was more in the art of confusion and conflating. And that's what we've seen. This whole jump to medical causation, given the earlier decision, Your Honor, I showed you what the jury found. They found causation. They found the inadequate warnings. And this is one where I hate when Milwaukee now tries to attribute blame to Hannah, since Hannah's already settled, now that Mr. Fears has moved from the Hannah party to the Milwaukee party. But it was Milwaukee who created the tip card. And that tip card told you the conditioning period. So when he gets up and says, you know, no one talked about the manual, Milwaukee didn't create the manual. That's the Hannah manual. It is the Milwaukee tip card that's included in the box. They actually put that in the box. The manual is created by Hannah. So references to Hannah and what they didn't read about Hannah is irrelevant. The actual issue, when you boil all of this down when it comes to Milwaukee, is Milwaukee provided the tip card. The tip card was the only item that said how long do you need to condition these probes to get accurate readings from this meter. That's the tip card, which Milwaukee was responsible for, because Jason Brown put those in the boxes. So this discussion about manuals, and maybe Mr. Fears didn't know that. He may not have. But there were no instructions on conditioning in the manuals. So, Your Honor, unfortunately for Mr. Fears, despite the color commentary on the guy in the dungeon or in the basement with that cauldron, I actually saw a witch net, it could have been as well. The manual issue is a non-issue. The Casey Aiken issue actually supports our position, because Casey Aiken said this is what determined how much the C2 concentrate we put into the water. If the alkalinity was not high enough, they put more in. The other thing that I would say, Your Honor, which is again strange to me, in the Gallagher case, we had 2018 cases, 2019 cases, 2020 cases. All of them had hydrazine, and the FDA, when they did their testing, they tested 3 solutions of the concentrate, found hydrazine in all 3 of them. And this was in 2021. When UNFW tested the water in 2023 in retail bottles, again, every sample, 7 out of 7, showed hydrazine, 2 of which were below the reporting requirements, but still showed traces of hydrazine. There is no way to get around it, and I will tell you, with Mr. Odou sitting right here, he doesn't dispute. His experts do not dispute. Even Milwaukee's expert, Mr. Babcock, has said in his report that hydrazine should not be, a single drop of it should not be in bottled water. There is no way to get around what the court has already decided, and there's no support for the, I would say, verging on ridiculous argument made in support of this one. And I say that just tongue-in-cheek, Your Honor. I understand the creativity of Mr. Fears, and I appreciate it. Again, I thought it was good, a good picture he created in this courtroom today. But it doesn't support the court leaning or going away from, or straying away from its inclination, Your Honor.
Thank you.
Thank you so much.
Other rebuttal?
Your Honor, before I get to the rebuttal, I just want to make clear that I'm copywriting The Alchemist, so we don't see the opposing deck of Mr. Kemp or Mr. Parker. Your Honor, again, we're talking about warning tip card. I don't see the evidence of people reading that in the depositions. They could have easily pointed that out. We raised that in our motion. I'm also talking about the batch. He talks about, yes, it was, FDA did find it in the concentrate in 2021. That does, you can make whatever comment of whether that's in 2017, 2018, 2019, but the fact is, it was 2021. Again, we were looking at these batches, and that is a part of the causal chain. Finally, and I know your ruling, I've put in your earlier ruling, look, I'm talking about causation, I understand that. I put on my helmet, I'm in the cannon, I'm going to be shot through that wall. Probably won't, it looks like I will not get through that wall. But I'm laying out the foundation, the property, and the reason why there are issues here that, you know, we disagree with your earlier ruling. And that, and understandable that. And one of the key things is the medical causation. Each person has a different medical history, a different medical issue. We have different batches. That is a issue. I understand your ruling. And so our motion is on these different areas of the causation where they cannot prove. And so we ask that you grant our motion.
Yeah, thank you very much. And, you know, to be clear, I give you all a hard time sometimes, including 5 or 10 minutes ago. I appreciate zealous advocacy on both sides. I'm going to stick with my initial inclination and deny Milwaukee's motion for summary judgment number 1, because 2 things: 1, genuine issues of material fact exist, and or 2, to the extent there are, they are actually in support of plaintiffs to a large extent, or to the extent there are no genuine issues of material fact. Rather, they largely support plaintiffs, as I've already indicated in prior ruling. So, Mr. Parker, prepare that order. That one doesn't need to be very long, I don't think. Submit it to Mr. Fears et al. For review.
Thank you so much.
After this next one, we'll probably take a break. So the next one's Hannah's motion for summary judgment 2 regarding plaintiff's punitive damages. I assume Milwaukee wants to do this one.
Yeah.
We concur with Mr. Kaufmann. There's no substitute jointer.
Okay.
So we'll just pull that in.
So that one's vacated then? Okay. Poor law clerk's getting his work out. Let's see, don't sit down. Number 3, all claims of plaintiffs Ryan Carrier or Rika Carrier individually on behalf of Finn Carrier. Was that one already taken care of?
It was, Your Honor. Thank you.
Okay. Well, we're moving along, so Okay, so this one's an interesting combination. Costco's motion in limine number 1 regarding expert opinions of Dr. Hudson on causation and motion for summary judgment number 1 on causation. Are we saving this one?
I think that would be referred to whenever you hear the pretrial motions in the Kemp case.
I disagree with that.
Yes.
And I apologize, I'm looking to different attorneys, I'm never sure which one, who's doing what.
That motion exclusively applies to the claims of Ms. Cobb.
Okay, okay. So we'll vacate that one without prejudice for now. Okay. Oh. So I'm, this might be a good time to take a break. I'm prepared to start going into, number of other motions that may have quote unquote been for tomorrow, unless you all want a break for the day, but I'd probably rather keep going.
Can you just give us a heads up on the first 10?
Yeah, sure. Let's see. Yeah. Oh, yeah, so I think plaintiffs, so I start with plaintiffs' motions in limine. 1A through C or whatever, I think probably go
away
to
right.
to convey, right? So we probably start with 2, depending on what 2 is, and go, till we can, till about 5 or 7 break for the day.
Sounds great, John. Thanks.
Anything on that on the defense side?
Your Honor, I do think that, oh, I'm sorry.
No, if you want to say something, then we'll hear from them. Go ahead.
I was just going to say that I think that there are a number of motions in limine that we can probably take off or maybe changed in light of some of your rulings today. I don't know the best way to handle that. If it's
No, the best way to handle it is to go forward one at a time and take them on as we go. That'll be more efficient. Breaking for the day, we'll just lose 3 hours.
Anything?
No, I agree. I'm just saying in terms of a list of what we have to as we go through.
Okay. Anything on your side?
Is Your Honor just intending to go through plaintiffs' MILs, starting with 1?
However far we get, although
That sounds fine.
one I'll raise off the table now for today. Okay, so come back at 3:15.
Thank you.
Thank you, Your Honor.
So, motions in limine, the moving party will prepare these ones. Plaintiff's motion in limine number 2 to pre-admit the governmental reports. I'm inclined to grant, but welcome arguments. Want to save for rebuttal?
I'll save it for rebuttal.
Okay.
Good afternoon, Your Honor. Matthew Kaufmann on behalf of Real Water. Very quickly, in regard to plaintiff's motion to eliminate number 2, the only things I would like to bring up is, 1, that if the court is inclined to grant this, I ask that the court report is redacted to remove references to the consent decree, because we do have a motion to eliminate to bar reference to that, and that is unopposed. As to the other issues raised by plaintiff's motion to eliminate number 2, I just, strike that. Let me restate that in a better way. I'm perfectly happy to go on the briefing and to that, a lot of the stuff in here is highly technical and is confusing, and some basis and some foundation should be laid for it before it's given to the jury. Thank you, Your Honor.
Thank you. Anyone else in any opposition?
Your Honor, Noushan for Costco. I had spoken with plaintiff's counsel over the course of the break about the issue of how to handle motions in limine with respect to Costco. And my understanding of our agreement is that for all motions in limine and oppositions and such, as to Ms. Kave's case, those will be deferred until the time of her trial, and that to the extent that Costco had previously joined motions or oppositions, its arguments aren't waived, and we'll wait until her trial.
Is that fair?
That's correct.
Okay, yeah, so, no, thank you, and they've confirmed that, so that's good. All right.
Thank you.
Anyone else?
Your Honor, for Milwaukee, we would just ask that before you grant this motion, we did separately oppose this motion. We understand what the reason for it is. I understand the request is to have it pre-admitted without it coming through a witness. Again, the request is just that you defer a ruling on it until we understand what the evidence is for.
Thank you. So, any issue with redacting references to the consent decree?
No, Your Honor, I think I'm in agreement with Mr. Kaufmann on that.
Okay, so, other than that, anything?
No, I think Your Honor's inclination is correct, and I think that Mr. Kaufmann and I, having been through 2 of these trials now, understand that we will agree on the consent decree.
Okay, so, granted, subject to redactions regarding the consent decree. I'll tell you kind of general reasons why, although, you know, plaintiff's motion reply set forth specifics, but a lot of defendants' arguments on this one and some of the other ones really are more of a weight type of argument, like, for example, somebody just mentioning technical, etc. You know, those can certainly be explained, you know, presumably by a witness at the, you know, when there's testimony. But generally speaking, if there's extremely high likelihood and almost 100% that the exhibit's going to be admitted vis-a-vis testimony, I generally will grant motions to pre-admit, subject to, you know, certain exceptions, but, you know, there's no question they're authentic. This case, we're dealing with governmental reports. It's detailed. Those are generally admissible under various rules cited. So, grant for all those reasons. Put the reasons in the order. Put the consent decree redaction in the order submitted to everybody for review and approval. Do we go?
Thank you.
Okay. Similar, although a little different in terms of the evidence, but plaintiff's motion limiting number 3 to pre-admit FDA concentrate testing reports. Inclined to grant that, essentially for reasons already stated, but welcome any arguments. Safe for rebuttal?
Yes, Your Honor.
Okay.
Your Honor, for Milwaukee, my opposition is for the same reason as the last one.
Sure.
Thank you.
Thank you. Thank you. So granted for all the same reasons, put the reasons in there, submit to everybody for review and approval. May sound a bit like a broken record, so I apologize, but plaintiff's motion limiting number 4 to pre-admit Loma Linda article from the American Journal of Gastroenterology. Inclined to grant that and specifically to this one in particular, last trial I had last fall, that one of your colleagues who's not here was trial counsel on one of the sides, proved to me or showed to me, demonstrated to me that articles such as this can be admitted without essentially any testimony. So inclined to grant that, but I mean, not fully without any testimony, but anyway, inclined to grant it for all the reasons. Save for rebuttal.
Yes, Your Honor.
Anybody in opposition?
Same opposition
Same.
for Milwaukee.
Thank you. So granted for all the reasons. Motion reply. Okay. Plaintiff's motion limine number 5 to pre-admit Eurofins retail size bottled water hydrazine testing report. Inclined to grant. There's no genuine dispute as to authenticity. Vast majority of, I mean, similar type of reasons, vast majority of defendants' arguments go to weight, not necessarily the admissibility, up for the jury to give it, you know, the weight they deem appropriate. And I think I might have mentioned this earlier too, but generally comports with my practice in trial. If there's high likelihood it's going to be admitted during the trial itself, I'll go ahead and pre-admit judicial economy, etc. Save for rebuttal?
Yes, Your Honor.
Anything in opposition on this?
Same opposition as to the purpose.
So granted for all those reasons, all right?
Your Honor, the next four were withdrawing,
Okay,
so for the record, I can tell you which ones they are and why.
sure.
Plaintiff's motion limiting number 6 to pre-admit the YouTube video of Blaine Jones. The purpose for the YouTube video related to the warning case against Milwaukee, so we don't need to use that at this point, so we'll withdraw that. 8 is the real water epidemiologist. Again, that related more to the Milwaukee case than anything else, so we'll withdraw that. 10 is the life expectancy table for Quebec, so that would be moved for this trial for the next one. 11 is the Christopher Brian Wren medical record. And again, that went to the Henderson plant versus the DI plant issue that's now moved. So we're withdrawing 11 too.
Okay, so 12.
Your Honor,
Excuse me, I said 11, I meant 10.
Yeah, 9 and 10.
Okay, okay, this number. So which one should I go to then?
The next one would be plaintiff's motion limited well, on my list. I don't know what.
Was that, just for some clarification,
Sure.
Is 7 withdrawn, the 10?
7's not on my list.
Okay.
I'm just going off the list that Eric gave me. We have the poster in order. 7 would be withdrawn too, though. 7's the tenor one. Yeah, who would withdraw plaintiff's motion eliminate?
I apologize, Your Honor,
That's
because what you just said that you're going to go through them numerically.
Yeah.
Of course, we got a list, very helpful, of how it was the hearing was going to be tomorrow, and so I
It's fine.
apologize.
It's fine. We're moving super fast, so no
But
worries.
just to keep the ball moving, we're not going to object to someone withdrawing a motion.
Yeah, tenor, we would withdraw that because that's not,
Okay.
because of the course of previous ruling.
So which number do we want to?
probably 11 would make sense, but
Yeah, 11 is the pre-instruction of the jury room.
Okay. Okay, so yeah, plaintiff's motion eliminating number 11 to pre-instruct the jury on standard product liability instructions. So generally, when asked, I will do some form of pre-instructions, but I'm more cautious in terms of, you know, what to pre-instruct versus what we may be doing at the end. So I'm inclined to grant in part, deny in part. Plaintiff's motion eliminating number 11. So grant in part to pre-instruct, give instructions based on the 2018 pattern jury instructions. Deny in part on the adulterated instructions. There's no support provided for them. Certainly if defendants have vis-a-vis those 2018s, you know, you can confer in good faith, see if you want to add any to what plaintiffs have proposed. But that's what I'm inclined to do, but we could go through them one by one. If I skipped any, I've got notes individually as well. Like, for example, 5, probably not inclined to grant that one, but 6, similar, 7, similar. But so the 2018 essentially, but welcome arguments begin with plaintiff if plaintiff has disagreement.
So, Your Honor, just so I'm clear, you're inclined to grant the proposed instructions to the extent they're in the 2018 pattern version and give those instructions and not any of the others that aren't in the 2018 version. Is that correct?
Yeah, and so to be a little more clear, so inclined to grant and instruct, give 1, 2, 3, 4, no 5, no 6, no 7, yes, give 8, no on 9, yes on 10, no on 11, and then no on the 3 adulterated. Now I may be wrong, but some of even the ones I'm inclined to grant, I want to make sure, because I think defendants may have pointed out, and I just can't remember specifically as those 2018 ones, if there's any changes to any of those that plaintiffs are proposing. I'd love to hear about that if I missed something. But, so that's what I'm inclined to do.
Yes, Your Honor, I think that sounds reasonable. Let's submit on.
Okay, and you can have a rebuttal if they.
Your Honor, Joel Odou on behalf of the Real Water defendants, just very briefly.
Sure.
We hear the court about pre-instructing the jury using the 2018 instructions. Based on some of the rulings today, based on the stipulation of liability, I think some of those instructions no longer fit. And what we would suggest is the parties meet and confer and see if we can do a better job on noodling some of these down based on the rulings today. In particular, I don't know that 1, 2, 3, and 4 fit anymore, and so I think we should
And that might be a really
fine tune them.
Okay. Anybody else?
Yes, Your Honor. Given your earlier rulings, we join with Real Water, given the issue of preclusion and what you ruled. Some of these instructions do not seem necessary. I mean, and so this is just kind of. I think a better course, Your Honor, is if you allow us to meet and confer and figure out, because of course you have general statements about the case and all that, but going through all the evidence or going through the elements of these claims, where one, either they were stipulated to by Real Water or you have made a ruling on that, I I think there's some prejudice, and I think there's some issues there, and I think giving us opportunity to try to work something out with plaintiffs made, so at least they get a flavor what the case is about, they understand what it is about, but talking about all these elements that are now, you've ruled that have been met, which we disagree, of course, with, I think would be the better course.
Thank you very much. You're done.
Your Honor, I'd just add that just because there's a stipulation doesn't mean that it's not helpful to pre-instruct the jury on what the claims are, what the stipulations relate to, and providing the information for all the reasons we put in the motion as to why pre-instructions can be helpful to a jury who doesn't understand that information at the outset, and providing it to them as a guide as we go through. So I would disagree that the stipulation has any effect. These are the pattern jury instructions. It's, we've agreed on these instructions in the past in terms of the close of evidence. So providing these basic instructions at the outset, it still serves the same purpose of why we made the motion. So we would agree with your inclination in the ruling that on the ones that you were inclined to give, and we would forgo the ones that you were not inclined to give.
Thank you very much. So I'm going to change my preliminary to some extent. So not changing because I'm going to be giving what I would generally characterize as non-controversial, hopefully, pre-instructions, and yes, the 2018 ones in general would fit that in general. But as defendants point out, based on prior ruling, which they, disagree with, which is fine, but they understand that, that's the ruling, so therefore, okay, some of these 2018 may not really apply, or may be needed to be tweaked. I do agree, on plaintiff's side, hey, let's give some pre-instruction so that jurors know better what a complex case like this is about and what the law vis-a-vis the case is. So I'm going to order, yes, I'm inclined to still give pre-instructions, but I'm going to order the parties to meet, confer in good faith, come up with, some that you can agree on. If there are ones that, plaintiff thinks still, I'm still not inclined to give, what I would call the heavily disputed one. But if there are inside those 2018, or, if one of those disputed ones that I wasn't inclined to give, it needs to be, or plaintiff feels it would need to be put in because there's a gap in the 2018, I'm happy to consider that. But, so we can confer in good faith, and we've got a couple weeks still before or 3 weeks, I think, whatever it is, before we start the trial. So let's talk about, at least on Thursday, when you're going to come see me again on the...
Your Honor, if I could suggest, I know we are scheduled to have the pretrial meeting between counsel next week,
Okay.
I believe, and we're coming back on the calendar call date. If we can present you with the instructions that we agree on, if any, and then any ones that we want that are...
So I already gave you a follow-up calendar call.
We do have it.
Yeah, so do that, meet and confer before that, and yeah, come there prepared to go over. Yeah.
Thank you.
Thank you. Is 12 still need ruling on designate Blaine Jones?
Your Honor, your rulings in terms of Milwaukee, as well as the concessions made by Real Water, they really make it not as important, but we still have the punitive damage claims against both. And so their testimony, I think, is still important
Okay.
for purposes of that. So, and I'll just reserve
So,
a rebuttal in both the Gallagher case, Your Honor, and the Hunwartson case. Mr. Blaine Jones was found to be a managing speaking agent. Mr. Carl Salvaggio was found to be a managing speaking agent in the other case as well. And we've given you all of the reasons why in our briefing, Your Honor.
I mean, I climbed around 32, subsection 3.
Yes,
Use
Your Honor.
the depots for any purpose. So let's do 12 and 13 same time. Who wants to argue in opposition?
Good afternoon, Your Honor. Matthew Kaufmann on behalf of Real Water again. Just very briefly, I'm not disputing the law that plaintiff sets forth. I just think that there needs to be a distinction here. And what plaintiff is doing, frankly, is using a term from discovery, which is managing speaking agent, to impart an air of importance on one of my witnesses. And that's all it is. And that's my sole objection, Your Honor, is I think that it's unduly prejudicial. And, you know, we discussed this in our briefings, and I'm pretty happy to submit on the briefings with that.
Yeah, so let me see if I understand what you're saying. So you're essentially acknowledging, you know, under 32.3, and correct me if I'm wrong in any of this, you know, under 32.3, they're allowed to use depot for any purpose, but you're saying, hey, we don't want you, judge, to tell the jury, or somebody to tell the jury, judge has found that he's managing speaking agent of Real Water. Is that what you're saying? Or?
That is correct, Your Honor. I'm not objecting to the use of Mr. Jones' testimony as it applies to Real Water. I mean, that's black letter law. I just think they're trying to give him an air of importance that is unnecessary and unduly prejudicial. That's my position.
Thank you. Anyone else on 12 and or 13?
Sure, Your Honor. Our opposition is to number 13. I believe it's for Jason Brown. And I want to take you just a sec.
13's Carl Salvaggio.
14.
Yes, it's Carl Salvaggio.
Oh, is 14 same but a different person?
Well, not exactly, but thank you all for clarifying that for me. So I agree with what Real Water's counsel just said, but I have to add that this managing speaking agent, as I understand, it has to do with the scope of attorney-client privilege when it has to do with the employer as a client or a business as a client. So I 100% am on the same page with the argument that I don't know where this term comes from, but let's not use it during the trial. Now, Mr. Salvaggio, I do believe, gave testimony as a 30B6 witness. That's something separate. But Jason Brown surely did not. So I think these special terms need to be erased from all of this. If the plaintiffs want to use our folks' deposition transcripts for trial, okay.
Thank you very much. Anybody else in any opposition to 12, 13, or 14, I guess? A rebuttal. So, tell me about, the quote-unquote managing speaking agent designation versus, hey, yeah, I agree, you can use the depots for any purpose.
And Your Honor, we briefed this, I thought, fairly extensively, and I think that Mr. Kaufmann certainly recognizes the case law on the subject. And I understand his point. He's looking more for a lack of the court's determination of his importance, of Mr. Blaine Jones's importance. And I understand that. And we use the rule, and we use the case law that we've cited to point out the use of the deposition. And that's what the court is already inclined to agree with. We're not coming here to say he's the managing speaking agent, ladies and gentlemen, now you listen to the deposition. We're simply going to play the deposition in the portions that we find to be relevant. And so I think we take care and address Mr. Kaufmann's concern, and I understand his concern. it's to me, it's tantamount to how the court has changed on qualifying an expert now, and how that approach has turned.
The Supremes may say that's always been the rule, but I hear what you're saying.
Yeah, we've had this discussion, Your Honor. But that's the point. And so we won't do what Mr. Kaufmann is concerned about. But I will tell you, using Mr. Carl Salvaggio and Jason Brown was the general manager of operations for Milwaukee. He was the one who gave testimony in this matter. He was used his testimony was used in the last deposition. In fact, Mr. Kaufmann or Real Water used his testimony. We used his testimony. I believe Milwaukee and Hannah used his testimony. So I am perhaps Ms. Davis, because she did not participate in that last trial, is not completely aware of how.
No, I didn't either, so don't feel bad.
Right. So I don't want to. I can't anticipate all of her concerns, but I can tell you, based upon their opposition and our motion, Your Honor, we don't intend to suggest to the jury, that the court has made some special pronouncement in terms of the value of their testimony, just that we get the ability to use it. And while I'm here, Your Honor, Carl Salvaggio was the president of Milwaukee. So certainly he was a managing speaking agent. Mr. Blaine Jones was the vice president of Real Water, and in fact was still identified as the vice president of Real Water when the Gallagher trial started, and when the Hunwartson trial started, I believe, Your Honor. So they're all very important people with both Real Water and Milwaukee, Your Honor. And I think the court's inclination is correct based upon the law.
Thank you.
Thank you.
So I'm going to call, 12, 13, 14, Grant Part denied in part. These are always without prejudice. Grant Part plaintiffs are permitted under 32 subsection 3 use the depots, however they deem appropriate, subject to, particularized objections. My ruling on those, but that's super clear. In terms of the additional request to identify them as managing speaking agents denied without prejudice, you can identify them to the jury using their actual titles, whether you get those titles from their deposition testimony or defendant documents, those types of things. You can use those, but don't get in front of the jury and say courts found that they're a managing speaking agent. Don't use the term managing speaking agent. Use their actual titles.
I'm sorry, say that again, Your Honor?
Use their actual titles.
We will, Your Honor.
Yep.
And the only other thing that we wanted to point out, but I think it's implied, Your Honor, but I'll say just to make sure. Under Rule 30b-6, their testimony binds the company. And so I don't know if that's an issue, but I figure I'd put it out there.
Yeah, so somebody pointed out not all of these were identified as 30b-6s, right?
That's
yeah.
right, Your Honor.
Yeah.
Yeah, and also, Your Honor, just real quickly, Matthew Kaufmann on behalf of Real Water also point out that only one of Blaine Jones's depositions was taken as a 30b-6 witness. The other one was taken as a personal deponent. So there might be some issue there, but I think that would have to be parsed out at the time of trial. I don't think that's something we could fully resolve right now.
Your Honor, the rule says managing speaking agent or 30b-6. That's what the rule says. Or is actually in the rule. And so that's the importance. But we still would not use anything other than their titles in describing them. So this ancillary topic that I brought up was for purposes of, and I think you'll see this in the jury instruction as well. I think just having jury instruction on this. But their testimony on behalf of the company as a managing speaking agent or a 30b-6 witness binds the company. And I think that's verbatim in the rule.
Your Honor, if I may, real quickly, just to clarify a point. I'm not sure, I'm looking at the rule, and I'm not seeing the term managing speaking agent in NRCP 30, and I'm not trying to
So
say
I'll read the
Mr.
rule as quoted in the plaintiff's motion pursuant to NRCP 32 subsection 3. An adverse party may for any purpose, an adverse party may use for any purpose the deposition of a party or anyone who, when deposed, was the party's officer, director, managing agent, or designee under Rule 30b-6 or 31a-4, close quote. I do find to be clear under 32.3, and this may not have been clear, but the three individuals we are talking about fall within any one of those particular categories, as implied by me saying that even defendants agreeing, I think, you can use those depots for any purpose. Now, whether it's quote-unquote binding, I'm not getting into it this time.
That sounds right. Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. Okay. That was 13.
That's 12, 13, and 14.
Okay. Yeah, 14 we did, yeah. Brown.
Thank you.
Yeah. 15 at the end, okay.
Actually, it's
Uh, 15, plaintiff's motion in limine to preclude defendants from arguing that they can delegate their obligations to government agencies or that prior permitting, past inspections, or compliance with other health or manufacturing regulations is a defense. Inclined to grant that pursuant to the actual title limit, in some of these, there's this question of some of the motion seems to be limited to what I just read in the title, other does not, but inclined to grant at least in part as to what's asked for in the title, and also the reply, the conclusion in the reply. Return to that. Preclude defendants from arguing or implying that they can delegate their obligations to government agencies or that prior permitting, past inspections, or compliance with other health or manufacturing regulations is a defense. So to be clear, be limited, so it might be better to call it grant part, deny in part. It's not precluding defendants from setting forth facts of, these were inspected, here's what happened. Those are facts and factors, but it would preclude an argument of, hey, this is kind of a generalized, but we complied with FDA whatever, therefore we are, not liable. That's the law says that's not true, so that type of argument would be precluded. But certainly a lot of this stuff is relevant, admissible, just preventing the defense, alleged defense of saying, hey, we complied with this or that, or this inspection occurred, therefore we're not liable. That's what would be precluded.
Yeah, and Your Honor, I was going to say, you don't have to labor over this one too much. I think only Costco opposed it. And so I don't think
sorry.
Yeah. The other thing is, but you hit the nail on the head on the law. So.
So you would try that?
I don't think Real Water opposed it.
We joined Costco, but we echoed what the court said. So
Yeah.
I think we might have an agreement here.
Okay.
Yeah, Your Honor. And Your Honor's comments are very similar to ones you hear in the construction context, where general contractor comes in and says, listen, the house was inspected when we left, and we got a certificate of occupancy, it can't be defective. But as you know, as the court said, you can't use that as defense.
Okay.
But thank you, Your Honor.
To save time, Your Honor, I think 16 is kind of the same thing. And we could probably roll it together. I don't know, it's plaintiff's motion, but I don't want to step on their toes. But 15 and 16 are pretty much the same thing, and the court identified exactly our issue, and we agree with the court senate.
Okay, so put that as the ruling. To be clear, you know, it's not precluding all those things that I said. So 15 and 16. Did anybody else oppose, though? I want to make sure I'm not skipping over any. Okay. Okay. 17. Oh, 17 we skipped, okay.
Yes, Your Honor, I believe that was intentionally omitted, a mistake in numbering on our part.
That's okay. So let's see, 18. 18 and. Plaintiff's motion to eliminate 18 and preclude reference to the fact that Blaine Jones is now a plaintiff.
Yeah, Judge, we've argued this motion twice, and basically what we turned it over to the defense, however they wanted to handle it.
Oh yeah, is this the alternative kind of?
Yes, because their argument is they're entitled to say he's a plaintiff because he has a financial bias. You know, I don't want to have a reversible issue on appeal, so I said, if you want to do that, do that. If you don't want to do that, which I think is probably the better course, but we've just said they can vote on it, is whatever way they want to go on.
Limited to his video depot. Is that this one?
That's not in this one, Your Honor.
Sorry.
This is just the fact that he's a plaintiff or not.
Yeah, so to balance these competing concerns, plaintiff offered to solely use his depots, not call him live.
And we still make that offer, Your Honor.
Okay.
If they want to do it that way.
Okay. Anything from the defense?
Joe will do for real water. Nothing to add on our behalf. I think some of the co-defendants may want to.
Okay.
Your Honor, I don't really understand why this motion was filed. It doesn't seem like plaintiffs feel real strongly about it, and in that event, I think our opposition stands that we'd still like to have the opportunity to impeach this gentleman with information if we so choose at the time of trial.
Your Honor, that's fine. The motion should be denied then.
Okay. So
As
denied.
I'm pretty candid in the motion. I think it goes both ways.
Maybe they'll, yeah, so denied without prejudice. Plaintiff's motion limiting number 18, denied without prejudice. Okay. 19, preclude testimony and arguments regarding purported lack of injury claims in lawsuits, quote, legal history related to real water prior to August 1, 2020 or outside Clark County. I really liked what Judge Kishner did. I'm probably inclined to follow that, which I think would probably be called granting part, denying part.
Judge, I don't know if this might be moot though, because this pretty much pertains to retail bottles.
Okay.
That didn't have anything to do with property on drugs, so. It's our motion, but I think it's moot at this point.
Withdraw it then?
The defendant who's gonna offer it's not even here anymore about beverage.
Okay.
The only reason we were still arguing is because Costco joined it.
Okay.
So that would.
So that you could re-raise it if needed.
Yeah.
Okay.
I think we can withdraw it.
Okay.
Or, alternatively, we can go with what Your Honor said.
Well, I gave away what I'm inclined to do in the future, I guess, is probably how it's.
Yeah, I think maybe we ought to stick with Judge Kishner's rule and not think about it.
That's okay. Well, so we'll call it withdrawn. You could refile in the future if you deem appropriate. I should ask before I give inclinations. Hey, is this one still live? Let's see. Okay, 20. Preclude Hannah/Milwaukee from arguing the plaintiffs must propose an alternative warning. Is this one still
I
live?
think this is moved, Your Honor. We can call it moved withdrawn.
Okay. 20 withdrawn. 21. Preclude meter defendants from arguing and inferring that is a defense that ORP meters do not cause or measure hydrazine.
Same thing, Your Honor. I think we can withdraw that.
Okay, withdrawn.
And the same thing would be 30.
Say that again.
Excuse me, the same thing would be 22.
22. 22 withdrawn.
Yeah, that would be withdrawn too, Your Honor.
20.
If I can find it.
Sure.
I'm sorry, Will, what number did you,
It's,
was the last number you
motion
withdrew?
made 23 to preclude the cumulative. Since there's not remaining defense causation testimony, we can withdraw that, Your Honor.
Okay, so we're up to withdrawing 23.
23.
Okay, so 21, 22, 23, all withdrawn.
In 24, I view that as mute, but I had a conversation with the council and they thought maybe it wasn't mute.
Okay. Well, let me turn to that. I'm having a hard time here.
Is there 24 or is this 25?
There's a 24, Rev Chuck.
Oh, okay, thanks.
Yeah.
Yeah,
Preclude Rev Chuck from offering opinion purport lack of ozonation, thank you, at Henderson plant would degrade hydrazine.
Yeah, Judge, I don't think that they're gonna call Rev Check at this point. If they are, we can address whether we need to argue this or not.
I believe we're water joint plaintiff's motion.
We did not oppose this.
Okay. So I guess let's call 24, so nobody live, Costco did oppose it, but we'll
No, Your Honor.
say that again.
No, Your Honor.
Yeah, so with 24 withdrawn, okay.
I think we might as well just grant it. I don't think anyone's gonna call Rev Check though, so it might be moved, but I think if they do call it, it should be granted.
Okay. Anybody want to argue in opposition to 24?
No, we agree with plaintiff's Joel Duca with all.
And you said you didn't oppose?
Not our expert, Your Honor.
Okay. Anybody else? Going once, going twice? So 24 granted. Okay. Okay.
Yeah, Your Honor, this is Babcock, this is the meter tester, so I'm assuming they're not gonna call him, given the court's ruling, and for that, the reason we're gonna move. So we withdraw it based on the understanding they're not calling Babcock.
Anybody have anything to add?
Your Honor, we're not gonna oppose to withdrawing it. I mean, I'd like just the opportunity to think about how that might affect a punitive damages stage. I don't know the answer, to be honest, but I'm not gonna, if they're gonna withdraw it, we can address it if somehow there's, I can talk with Will and we can.
Let's defer it till,
Yeah.
let's defer it till tomorrow or
Thursday.
Want to think about it a little bit?
Yeah, let's
Well,
at
if
least.
you withdraw it, I mean.
At least
I'm not gonna
Thursday.
withdraw it.
Yeah,
You're
so,
Babcock.
so Thursday, we can talk about, yeah, cause I understand, things happen. So 25 we'll put on for Thursday, and, you know, if you still need some more time, you'll be in front of me more than one time before the trial, so. 25 will defer at least until Thursday.
Error 26, I
Did you
choose
note
move.
that one? Thanks. Hold on one, sorry, hold on here. It's harder to turn pages one-handed. Okay, 26 you were saying?
26 would be moot because, I think it's moot, because Dr. Hall's a causation expert, so that would be moot, so we would withdraw. If you're interested, I could call him. We won't think about that.
Yeah, definitely want, yes, Your Honor.
Okay.
I mean, I'll think about it.
Same.
I mean, at this moment, do I have a clear idea of how I'm going to use them for the punitive damages? No.
Okay.
But
so,
I don't want
yeah.
to, you know, cut off my nose to spite my face. 'Cause
So 26, same thing, will defer at least until Thursday, and, you know, that is a compressed timeline, so if you need more time, just let us know. 27, nobody opposed 27, right, the marijuana one?
I don't think so, Your Honor.
So 27 granted, it's unopposed, 28.
The reason we filed this is because Real Water Tennessee was a player at one point, and we didn't know where they were going to play, but they don't seem to be involved anymore. So I think this is moved. We can throw this.
Okay, 28 withdrawn. Yeah, when I read this one, I was wondering, I'm probably missing something. It sounds like I'm not the only one who's missing, I guess.
Yeah, they were very active in the Gallagher
Okay.
case, so this is kind of a carryover.
Okay, 29, expert opinions, lay witnesses. If it's still in play,
I don't know if this one is still in play. Your Honor.
Okay.
I think this one, given that, you know, we have a concession as a liability from Real Water and the court's determination earlier, I don't see how this one is still in play.
Yeah, I agree, Your Honor.
so yeah, withdrawn, I guess, then?
Yeah.
Okay, 29 withdrawn. 30 videos and photographs. This one's probably still in play, videos and photographs. Oh, want to hear my inclination?
Yes, Your Honor.
Okay. So, of course, now, to the extent it involves plaintiff convey, it's not on the table anymore. To the extent it involves the others, decline the grant part, deny part, grant part, in terms of allowing the photographs. The videos I haven't seen, and so I'd be inclined to deny simply because I haven't seen them. I don't know what's in them. Certainly that'd be without prejudice as the regular type of admission on the videos.
Judge, there's one video in particular, the Williams twins. Could we play for the court, not today, but for tomorrow, and the court make a ruling on that? So that's something we've been inclined to use during all these things.
Any arguments, at least right now, as to the photographs? Not hearing any, so at least grand part is the photographs right now, and I did review, you know, the opposition briefs and everything, so, but photographs pre-admitted, video, how long is it? About
15, 10, 20 seconds long, Your Honor.
Oh, okay.
It's a video of the Williams twins while they're up there.
happy to watch it
Yeah,
tomorrow.
yeah.
Just remind me, because I won't.
And we could probably, can we pull up now? Yeah. If we put out a motion, we'd come back to this, Your Honor.
Okay. 31. 31's preclude Joseph Tagano's unrelated medical history. And if we've reached the point where you're not ready today, because we're way ahead of
Did
schedule.
you hear that, Judge? You have great ears. You tried to whisper it.
I'll have to share with you all a story from the very first trial I ever did as a judge. You'd appreciate it, I think. But yeah, we can play that video and call it a day. That'd be fine.
Final question, Your Honor.
Let's go off the record while they try and. Okay, say that again on the record.
Judge, this is with regards to motion to eliminate 30. These are the videos of the Williams twins up at the Salt Lake Hospital.
Okay.
And there's actually, I said earlier, there was one video, I think they broke it down into 3 videos.
Okay.
We want to get the audio on these?
Okay, that was one.
That was 2.1, Your Honor.
How long was that one?
I think that was about 2:30.
238, Your Honor.
Okay. That was 3.1 we just
That was
watched?
3.1.
Okay.
And I would point out that they're twin babies, so one's of one baby, one's of the other, so.
All right, and 4.1 was super short. All right, in terms of the videos, anything in opposition? Anybody, anything in opposition to the videos?
Your Honor, I think what, I'm sorry, Don Davis, who was one who argued this had to go to an inspection. I think the issue is unduly prejudicial. The image to the jury is going to be that they're still in this kind of state. Dr. Guthrie, who was their treating physicians, used, I think, the words made a quick recovery. And so if they're going to play that video and also have the kids come in and run around, I think that would negate that prejudice. But if all it is showing this video and that's left for I think it's unduly prejudicial.
Thank you. Anything else in opposition?
Real water would join in those arguments, Your Honor.
Okay. Any rebuttal?
Judge, this is the actual video of the condition of the kids, and it's not a good condition. I think we're entitled to show it to the jury because this is exactly what they're providing compensation for.
How long was 2.1 and how long was 4.1?
2.1, I didn't get the time on it, Your Honor.
26 seconds.
26? Okay.
Almost 27.
Okay. And 4.1 was
4.1?
12 seconds.
12? Oh man, my estimates are way off. I wrote 5 on that last one. So, in terms of 2.1, 4.1, I don't see the, relevance substantially outweighed by the undue prejudicial effect, and so 2.1, 4.1 pre-admitted per motion only number 30. In terms of 3.1, If you want me to reconsider that, especially for pre-admission, narrow it down to 10 seconds or so, and let's replay it another day. And
I narrowed down to 20-second, Sean.
yeah, you might want to try a 10-second and a 20-second version.
Try both, Sean. Okay.
I mean, I'll consider both. Okay.
Your Honor, I apologize.
No, that's okay.
Just because it's a long day.
Sure.
I have a headache, actually. Are you granting the motion or denying
So-
as to those videos?
So granting to pre-admit as to video 2.1 and 4.1, as to 3.1, which was a 2.5-minute one, plaintiffs are gonna see if I'll agree with them or not still on much shorter versions. I don't know what I'll do. So that one will take up, like on Thursday.
Thank you.
Yeah. Break for the day, come back tomorrow, we set for 11.
Sounds great, Sean.
Your Honor, maybe I'm throwing, we have with such larceny gone through all these motions. Does it make sense to come back on Thursday? Just because we have to have that day notice for the good faith settlement, and I don't know. I just throw that out.
The problem with that is Mr. Parker and Mr. Odou aren't.
Oh, yeah, they're not, yeah, that's fair. Yeah, so come back tomorrow, and what I would be scared of too is maybe tomorrow won't go as fast as today, but, yeah. The compromise, well, man, I hate, so do you want to come back at 1 tomorrow as kind of a compromise, or?
That's possibly
Yeah,
right.
that'd be great.
Let's do that, yeah, okay, 1 o'clock. Okay.
Sounds great. Thank you so much.
Thank
Sean.
you, thank you.
We'll be in recess until 1 p.m.